Mike, for Member Williams.
Yes.
Favor, yes. Apologies as well.
And
Okay.
I believe that there is also one from Member Holness.
A Member Holness?
Yes.
All right, well, we'll put it tentatively in case she shows up. Yes. Yes. All right. Okay, members, I just want to have confirmation of the minutes of the meeting that were held on October the 1st first, and then on October the 11th. The Ministry of Transport and Works, I was at the meeting of the 4th, but not the 11th. So I would ask members who have read the minutes and who were present for the meeting of the 1st, can I get confirmation? Any corrections or confirmation? Member Phillips, seconded by Member Stewart. And on the 11th, Member Campbell. All right. Yes, Member Phillips. Okay. Members, there is out of those meetings, the report has been prepared, which was circulated. I think what I will do, just to refresh members, because I know all have read the report, I'd like to just read the recommendations, the summary of recommendations on the report, and then we can confirm the report to be sent to Parliament, to be tabled in Parliament. The summary of recommendations are: 1, your committee recommends that the Ministry of Transport and Mining take the necessary action to resolve the issues surrounding compensation and other matters relating to air traffic controllers. 2, with respect to JUTC, we have the view that instead of expending large amounts of funds to rehabilitate buses that would soon have to be retired, it would be more efficient to purchase new buses. 3, consideration should be given to bonding persons trained by the JUTC and other entities in order for those agencies to benefit from their training. 4, consideration should be given to seeking insurance coverage from an insurance company and or establishing a pool of funds in order to compensate individuals hurt in accidents involving the JUTC buses. Just for clarity, members, my understanding is that there is a pool of funds that is utilized for the buses themselves. It's self-insured, but that the where there is compensation required, that goes to the accountant general. That, in other words, that's paid out of the general consolidated fund. But I'm just wondering, this is a recommendation. I'm just wondering if this.
Just repeat that section.
Let me repeat it. Consideration should be given to seeking insurance coverage from an insurance company and or establishing a pool of funds in order to compensate individuals hurt in accidents involving JUTC buses. Is that a recommendation of the committee?
Well, the pool of funds, I think what is established is that what comes in the annual budget for accidents for the JUTC is never adequate enough to take care of generally the current year, much less the back that is owed. But I think especially for the JUTC itself, I think, I mean, my recommendation would that there be a fund itself put towards or put together towards the compensation of these accidents, because the thing is that it is happening more regular now than it was in the past. It took years for those victims who met in the accident, I think somewhere in St. Catherine, going over precipice. It took years for them to even be compensated. We have seen
I think there was a court. The matter had to go to court.
And I think you have persons outstanding for years now who have not been paid. So
I'm just trying to clarify, because what I'm suggesting here, I think it's an important point.
It is.
In other words, I think what the committee is getting at, what we're trying to capture, is that there needs to be a more definitive way in which we treat with
yes.
the compensations of persons in accidents from JUTC and certainly
Yes,
the accidents, even though they may have their own repair and etc. And what you're looking at is the analysis of doing self-insurance or self-being government, as opposed to insurance
Going
coverage, and what the cost of that
would be. And because if you look at this report, even though we're not getting into it now, it's just the level of this is from the Attorney General's Chambers, accident claims involving GOJ vehicles, and I mean you're close to 200
million
a year.
Yeah.
In any financial year. So, and how many of the time frame of settling those compensations is also an issue.
Yeah, but I agree with you, but then again, I'm just saying my limited experience, the settlement is not solely the access to funds, although that may be an important part, but it's a determination.
In the case of the JUTC, it is, because even after judgment.
But that's the point.
Yeah.
Yes, I'm just saying that there's a. All right, so
Chairman,
members, I think it may be.
Chairman, I think as it is framed, I think it's quite in order. All we're seeking to do is to have the JUTC comply with the law, because the law says all public passenger vehicles. There was no exemption provided for in the law. So, so really, that's all we're seeking to do, to have them comply with the law.
All right, so
it's quite in order.
Absolutely. So it's in order. Let's leave it as it is and move forward. Number 5. We strongly recommend that consideration be given to selling or leasing the old Jamaica building, and that a suitable property be found to house the Transport Authority. 6, careful consideration should be given to the number of new licenses issued by the Transport Authority to carriers operating on routes served by the JUTC. 7, due to the inactivity at the Downtown Transport Center, we recommend that the facilities be leased in order for the Transport Authority to earn revenues. That's our recommendation. 8, the preliminary activities should be completed in a timely manner in order for the Portmore Transport Center to be constructed. Did we get a time frame on that?
There is supposed to be discussions being had with the ministry and the Belgians, because information that we got, well, I was chairing that meeting, and is that the loan is under threat.
The loan to do this,
right, from the Belgians, is under threat.
So basically, in other words,
so the GOJ needs to
move
to do their part before the loan can be dispersed or anything like that. And
the loan offer
before it lapses, which is at the end of this year. So it is for the ministry now to expedite their part.
I'm not certain.
So I know when we were in the meeting, we were meeting with them at the same time.
Okay.
So we haven't gotten a response of what came out of that meeting, so it would be good for us to get a response.
What we should do here is that we'll make a recommendation to Parliament. However,
I think as a committee we could also ask for an update from.
Yes, that's the point I was heading at. So the two things I would say, that preliminary activities should be completed in a timely manner in order for the Portmore Construction Center to be constructed.
The Portmore
Yeah, I'm just saying it's a recommendation to Parliament.
Yeah.
That Parliament ensures.
Yeah.
That Parliament ensures that preliminary activities should become, Parliament, that the preliminary activities be completed in a timely manner in order for the centre
ensure that this can be delivered.
Yeah, but it's not for it to be constructed, to ensure that the arrangements in place can proceed.
Yeah.
All right.
Yes.
And secondly, that your committee has asked for follow-up.
Yes.
On
the status
of this.
So we commit the item on the downtown transport center chair. I would suggest we amend the section that speaks to so we can earn revenue, but not only earn revenue, but to halt the expenditure because security is being paid for on that premises while it remains unused.
So really, due to inactivity, recommend the facilities be leased.
Right.
So it's not. It's
not just
really
to earn revenue, but
yeah, right. But you're really saying because it makes financial sense.
Yes.
So it's not just in order for it to earn revenues and stem the losses.
Stem the losses, correct.
All right. And lastly, given the significant revenues that can be earned from the industry, your committee is of the view that efforts should be made to fast-track the activities to be undertaken to privatize the Jamaica Ship Registry and address matters in relation to the legislative framework, customs, and immigration. Well, first of all, the privatizing of it is a policy decision. So is that policy decision taken?
Not sure. I'm not sure if we
if it captures
the issue of privatization.
No, that is not the right.
Yeah.
All right.
I don't think the issue of privatization.
Exactly. So
I think it was just the long delay in.
All right. Given the significant revenues that can be earned from the industry, your committee suggests. Let me do the wording. Suggests that matters in relation to the legislative framework, customs and immigration
be expedited to get
so that the registry can
we can be fully up and
functional.
functional. Yeah.
Okay. All right. Are there any other recommendations that may not have been captured?
To do with the railway JRC. A similar situation with Herzog, who the government had a non-binding agreement with, MOU with, which also expired at the end of last month. We need an update on the way forward to do with JRC. Right, because they met with Herzog. They have some proposals from other parties.
Yeah, because I saw in the report in the minutes where they had indicated
they gave them an extension.
Yeah, that
extension had passed, and they still had not gotten what was required.
So we really want to question and
Herzog.
We want to find out what is the status
yes.
of the arrangement with Herzog.
Right, and if
are
not,
they intending to continue discussions, or are we seeking
where we are
alternatives?
Yeah, good.
All right, members, just one thing. Was there a discussion about the train line from Montego Bay to Appleton?
Well, that is a part of that. They have multiple interests. Other persons have interest in that leg. So if Herzog is not on the table.
Yes, because there are multiple interests
right.
in
so that is why I'm
rehabilitating.
asking an update on the way forward if Herzog is not.
Quite frankly, just from my perspective, it is something that for the last 10 to 15 years, we've been having discussions about the Appleton Tour, which is a critical part of the tourism industry. It's important. It would give you at least one, it would be a signature attraction for Montego Bay.
The thing, Chairman,
and so the real issue with it is that in the overall railway, it is one of the more lucrative portions. So there's
it is only
the Transport Authority, the railway has constantly said they don't want to carve it out because it makes the whole thing less attractive. But in the period that we are not moving ahead with doing it, the country suffers and the tourism sector suffers because a significant attraction is not being addressed. So you're saying that based on the deliberations, this is caught up in the discussions with Herzog.
And the thing is, the longer that they keep giving an extension to Herzog, it slows down negotiation with any other entity. Now, I think, as you rightfully said, we have been batting around with this for too long. And if it is with Appleton or Campari, whoever it is, investing the amount of money they are in the Appleton experience, then the timing now is right for us to be able to attract others who would want to invest and to get the ball rolling where the railway is concerned. That leg itself is the most profitable. If it is just passengers that we're going to be moving between St. Catherine and Kingston.
Can I ask, right?
Yeah.
Is that, I mean, not having been here, there's always been some question about whether you were able to move passengers by train between the two, and whether or not it was.
The cost of the infrastructure is not something that the government can afford. And any private entity that is going to do it, that leg is going to be important to them too. Now,
No, that wasn't the question. I'm not, having not been here, there was some ambiguity as to whether or not the license for the toll prevented you having railway services or not.
I think there was a time frame in which you could institute the railway.
Yeah, so it's something that we should, all right. Yeah. So that's number one. And number two, in other words, although the question of where you would put the railway now, how you would reinstitute it.
Well, the initial MOU with Herzog was to do it in phases.
Yeah, because I think the railway actually went Spanish Town, not Port More.
Right.
So there are other issues. Yeah. Okay, members, just as a question, should we, in that part with the recommendation, with the question to Herzog, should we specifically mention the Appleton leg, that one of the reasons is to ensure that this as a development, or just it in its
overall, but also in the deliberations they mentioned the interests that others had in that leg.
Yeah.
So that is why we would want an update not only on the overall railway sector, but what is the way forward dealing with that aspect of it.
Okay. All right. So members, with that, with those recommendations, with those changes, we'll have the report circulated and tabled in Parliament next week. Okay, we now move to continuation of the review of the Ministry of Justice. Today we have the Administrator General's Department, the Attorney General's Chambers, and the Legal Reform Unit. I think we can move very quickly. I'm hoping we can get out of here fairly early today. So we can invite. Good morning. Good morning, everybody. Let me welcome Permanent Secretary, Mrs. Palmer, and your team. I understand today that we have the Legal Reform Department headed by Mr. Maurice Bailey, the AG's Department with Ms. Nicole Foster-Pusey, and the Administrator General's Department with Mrs. Lona Brown. What I would do, Ms. Palmer, is to give you the opportunity to introduce a team, or you could ask agency heads to do their, you can introduce them and they introduce their teams, and then I would give you the opportunity, if you had a few words you wanted to say, overview on this element of things. And then we could go through, as we have it here, members, the Legal Reform Department, AG's chambers, and Attorney General's chambers, and then the Administrator General's Department. We could just do them in order, and I'll give each agency head the opportunity to say a few words when we move from department to department. So, with that, over to you, Ms. Palmer.
Thank you, Mr. Chairman. Morning, Chairman, members. I would just like to, with your leave, sir, after the introductions, to make a few remarks following on my last appearance.
Yes, no, I said you have your...
Okay. The team consists of myself, Carol Palmer. Beside me is the Principal Financial Officer of the Ministry of Justice. Behind me is my Chief Technical Director, Grace Ann Stewart McFarlane, and Mr. Vivian Gordon, Building Property Consultant for the Ministry. To my two places, second place from me here on my left, is the Solicitor General, who I will invite to introduce her team. Followed to her left, Mrs. Lona Brown, Administrator General, and immediately behind Mrs. Brown is Mr. Maurice Bailey, Director, Legal Reform Department. I'll invite them now to introduce their members.
Good morning, committee members, staff. Accompanying me from the Attorney General's chambers, we have Mrs. Susan Reed-Jones, who is a director in the litigation division of the chambers, Ms. Stacy Morant, our Director of Information and Access Services, and Ms. Tamish Anderson, also a member of our Information and Access Services division. Thank you.
My team is made up of myself and one other person, Patrick Wright. He is the Finance and Planning Executive in the Administrator General's Department.
Yeah. Morning, committee. Accompanying me today is Ms. Nadine Wilkins, who is the Deputy Director of Legal Reform.
Thank you, team. I'd like to make two brief comments on our last visit here to provide some clarification. There was a statement I read in the media which contradicts what I said in the committee, and I think it's important that I have that corrected. When we spoke about judgment debt, and I was asked about it, I said that in terms of claim value, the health sector had the largest value per claim. Then I went on in speaking to the $900+ million of debt that we have now. I went on to speak that that debt included one claim for $249 million. I at no time said it was a health sector claim, because in fact it is not. It is a claim against the Jamaica Constabulary Force. The second point I want to be very clear about is the provision in the budget. As I imagine the committee would be aware, we make our submissions to the budget in November, as we're preparing now to do at the end of this month. And we submit our estimates based on what's in hand and projections. And so perhaps I was not very clear at the last time. So the provision we requested was for claims as at the time of the submission of the budget. Right. So we would not have had knowledge of claims coming in, though you can anticipate and do some forecasting. And so we would not therefore have paid the claims that would have come in at March 2017. Those are the 2 points of clarification I'd like to make. We would have submitted,
members understand fully?
Yeah, I'm clear.
Okay. Okay.
I don't see any variance from what at least I understood.
Yes.
The last time.
Okay.
yeah, I just picked up something different in the news, and so I like to be carried factually. So,
you know, the main source, the two main sources of misunderstanding in your mind are one, that while the actual amount of the debt was correct, and a large part of the debt is the health, that the $240 million judgment was not a health judgment.
no, Chairman. When we get a claim for health, it's usually big. Yeah, 30 million, 60 million, what have you. Most of the claims are from the Jamaica Constabulary Force, but a single claim is not usually very large. That's the point I was making.
Yes.
But then I went on to say that we do have a single claim for $249 million. I did not say from where, so I am providing the clarification this morning that that was in fact a Jamaica Constabulary Force
which
claim.
is what I was saying.
Yes, so that's what I want us to be clear about.
And the second point was that whereas we had said that you had received the monies to make payments to the claims as of this financial year, that it would only address those that you had put in for up to November of last year, just to take that idea out of mind that everything up to March may have been provided for at this point in time.
Thank you.
Luckily, we're now in November, so you're now in the second cycle.
Yes, and it's...
What she needs to settle those.
So you can get everything that you needed to settle in the next batch.
Well, we have made a representation already in terms of what we have in hand.
With sufficient projection.
And no, because we are now doing it to submit for the 30th what we have in hand plus our projections.
Okay.
So it's really one that's already in and another one that will go with the estimates as they are prepared.
Excellent.
If I had that pen, I would have approved it.
Okay. Now we have today the legal departments of the Legal Reform Department, the Attorney General's Department, and we have our executive agency, the Administrator General's Department. All of the ministry is involved in reform. So, under the JUST program, the Legal Reform Department was assessed to see whether it's carrying out its mandate, and also looking at the possibility of establishing a commission, a law reform commission, which would allow for the proactive, as I like to call it, proactive examination of legislation, so that we would not always be in a position of trying to catch up with reacting to issues in the society. That particular recommendation remains unsettled, but we looked at it because it would improve planning our legislation if we were looking ahead rather than trying to play catch up all the time. The department serves largely the Ministry of Justice. I think Mr. Bailey will agree with me, because we do not go forward with any legislation without the input of the Legal Reform Department, so that we are properly buttressed by research and by what occurs in other jurisdictions. Therefore, we can make a confident proposal to the government for legislative change. The department is staffed, but could well do with more people. It's a very difficult department to staff because of the work that it does. And so we limp along, but I will tell you that it's one of our star departments in terms of its responsiveness to what is requested of it. And I will leave the rest for Mr. Bailey to speak about.
He said in doing new legislation, you do not do it without consultation with the law reform.
Yes, or even amendments.
Amendments. So all new legislation being promulgated
by the Ministry
by
of
the
Justice.
Ministry,
yes,
is subject to the contribution from the reform unit. Okay.
Yes, yes. In terms of the Attorney General's department, you know.
Well, Spam, I'm wondering maybe it would suit us. You want us to do them together, or would you like us to, having given the overview of the Legal Reform Department, and then we could move to the next one, or you'd like to just give all three first, the overview?
Oh, I'm fine, whichever
Members,
works for you, sir.
Because it allows us, with freshness of mind, having had the explanation of the legal reform, to then have Mr. Bailey, yes, and then we can do it for the other departments.
I just have a little needling question or clarification I want, Ms. Palmer, in my mind. In terms of the remit of the Legal Reform Department, simply, is it to look at existing legislation, but legislations already on the book, and to promulgate updating or modernization of them in general, in a fulsome way, or is it separately or inclusive of? There are a number of legislation, for example, Chairman, that fines, for example, are way outdated. There was one case that came up in the courts recently for somebody being extradited or something like that, and the fine was like $100.
$500, yeah,
some nebulous amount, which cause a sense of usefulness of our laws by the ordinary Jamaican. And I raise it, Chairman, because part of the whole public order thrust in the country is for people having a sense that when you go to the justice system, justice will be served. So if the fines are, you know, minuscule or meaningless, there is still the absence of, a sense of the absence of rule of law. If it's nothing, if the consequences are minuscule, they'll just keep on reaching it, you know? So I just want to clarify that little point for me. If it is a bigger overarching legal reform in terms of
reform of the sector versus reform of specific laws.
Exactly.
It's both.
Okay.
It's both. And I will allow Mr. Bailey to speak to you about what the department is doing on upgrading, updating of fees and fines. But before he comes, I would just like to say their ability to do the depth and breadth of work is a function of their human capacity. Yes, both in terms of the posts that have been provided and their sheer ability to keep up. But in terms of the fees and fines, Mr. Bailey.
Before he comes, Mr. Bailey, I presume Mr. Bailey is a lawyer too by profession.
He is.
Yes, so I will piggyback on his legal competence.
So I think you're reiterating the point that it's a very important department.
Absolutely.
And one of the reasons that it is, in quotations, limping along is that it needs some filling out of its human resources.
Precisely, Chairman.
All right, Mr. Bailey, over to you.
I'm going to piggyback now on Mr. Bailey. And just to put in context.
Wait, hold on. No, just to say this, Member Jackson. Let me allow Mr. Bailey sort of to give his overview, and then we can speak to specifics.
Hang heavier on him after that.
Absolutely. Two lawyers.
Thank you, Chairman. The Legal Reform Department, I probably should give a little bit of context to what we do. As you may be aware, there are 4 legal departments: the Legal Reform Department, Attorney General's Chambers, the Office of the DPP, and the Office of the Parliamentary Council. Office of Parliamentary Council deals with the drafting of legislation, and the LRD deals with the content, essentially, of that legislation. As P.S. Palmer has indicated, the Ministry of Justice is our major client, although our remit is to service the government of Jamaica at large. So in their capacities as ministers.
No particular reason why I wanted to clarify that as we go along.
I am assuming that you are going to do so.
The areas of government, including members of parliament.
We give assistance to as many as we can.
Oh, I have an invoice to send your department, but go along.
Thank you, Member.
Usually it's the other way around, Mr. Jackson.
Thank you, Chairman.
Yes, thank you. Yes, so the Legal Reform Department does, our main work is to advise on legal policy in the area of law reform. And we do that both by research and analysis and giving advice, and also by what we call implementation, which is essentially all the steps from the formation of the policy straight through to its passage through Parliament. So you will see, along with the AGC and OPC, our officers in that corner box on many occasions, giving assistance to the process. Our work covers a wide range of legislative activity. I think the only thing that we don't really deal with typically is in relation to, say, taxation legislation and highly technical legislation. Other than that, we have dealt with a broad range of matters. The kind of work that we do, we have on record, for example, I think the first Director of Legal Reform, Justice Watkins, back in 1977, making the point that finding staff for the then Legal Reform Unit was a difficult undertaking, simply because of the nature of the work. It does involve a great deal of research, a lot of deep thinking, a wide range of knowledge. We have to bring to bear, unlike while our colleagues in the AGC, for example, are concerned about constitutionality and legalities primarily, we are concerned about the wider remit of law reform, and therefore have to take into consideration cultural, political, not only constitutional, international, and whatever other factors may bear on legislation. Our involvement sometimes comes at the tail end, very often in the middle, and sometimes from the very beginning. There are some pieces of legislation, for example, I would speak to the Cybercrimes Act, that was essentially developed from scratch in the Legal Reform Department, and there are many other pieces of legislation. Taking a little review of some of our work, our contribution to the legislative agenda of Parliament over the years has ranged from anything from 25% to over half of the legislation that has been passed by Parliament. And so in terms of our work, it's a wide breadth of work, but it has been a very small department. We are currently now with an establishment of 16, which includes 10 lawyers. We have, and where that is concerned, we have now 2 vacancies. One of our best and brightest is now a parish court judge. And I am sure that you've heard from eloquently and loudly from the DPP about what happens when we lose our skilled staff to the bench. So we have suffered from that, even though we are a more obscure department. But the nature of... Well, it's a loss for us, remember. So we have not that many people who can do a lot of the heavy lifting that is required with a lot of this work. So, for example, there are one major, how should I put it, a policy initiative that came to fruition, for example, the restorative justice. It's a major rethink of the way we approach justice and dealing with persons in the justice system, in fact, trying to divert them from the justice system and to produce a better outcome. And that is a major project undertaken by the Ministry of Justice. It therefore requires the kind of examination and insight and analysis. And it's not something that you can simply just give to somebody who's graduated from law school, for example. So a lot of experience is required if we're going to give the kind of advice that can be acted upon and that can be implemented and that is useful. Fines and penalties. The Minister of Justice earlier this year gave his undertaking that this would be something that will be under serious review, and the LRD has undertaken to do it. And so for the last 5 months, about 1/3, well, almost nearly a half now, of my staff has been involved in a review of the entire laws of Jamaica to review all of the fines. The project is almost completed in relation to that. And arising out of that, the fines will be adjusted properly. We're also looking at ways in which an omnibus mechanism can be implemented to ensure that fines are kept up to date. What I'd also need to reiterate to the committee, though, that there is a responsibility on the part of the individual ministries to keep their legislation under review, and that law reform is not simply something for one little department or for the Ministry of Justice. So in many instances where the fines go out of date, it's because they have not been looked at for a while, and then something happens, and then there is a crisis or embarrassment, and a lot of attention is paid at that stage. But in terms of the particular project that we have on hand, that should be finished by the end of this year. And hopefully by next year, things will be in place to make sure that all of our fines and penalties are brought up to realistic levels.
The piggyback question that I had for Mr. Bailey, and interestingly, you touched on it in terms of the fines and the omnibus legislation that you made mention of, which really touched my interest. I asked the question in the context of what the Prime Minister acknowledged yesterday in the Zozo report here in Parliament, that we have an epidemic in crime, serious crime, particularly murder and shooting. Given that acknowledgement, which many of us accepted long ago, there is an urgency to attend to matters relating to crime and violence. One of the complaints that we get is the court system, beyond what you're talking about. We dealt with it the last time, the backlog in the courts, insufficient court space, etc. All of that was discussed the last time around. But what I mentioned earlier about the fines and to what extent they don't serve as a deterrent for criminal activity, given that urgency, that epidemic of crime and violence, is it possible, Mr. Bailey, that we could look at a menu of legislation, like what was done with the MOCA bill, where about 45 pieces of legislation, major crimes were pulled from them and put on the coverage by MOCA. Could we look at a menu of legislation, take those offenses, and then create an omnibus provision to say, I'm speaking in a raw way, might need, upon close examination, refinement. The fines which are in such and such a range, sort of index some updating. So fines up to so much dollars automatically go to so, using some conversion factor. In other words, if you had a fine on the book that was $100 now, and normally in today's time it would be 10,000. So you have a conversion factor that brings it up to 10,000, just for argument's sake. So something that, rather than have to go through all of those legislation and do individual amendment to them of just the fines, that omnibus adjustment of the fine will just make one sweep and bring them up to speed in a more current level. That's where my thought process was. Tell me if I'm far-fetched or if it is doable.
No, you're not far-fetched, member, and you just basically described the system that is used in Australia. And that is something that we're contemplating we are proposing here, that approach that could be taken. But before we even get there, we still need to know what it is that we have. So the exercise that we're undertaking is a necessary one. We need to know what the fines are, what the offenses are, what the penalties are, what the fines are. And so that this very hard slog of going through all of the laws and finding these offenses is something that has to happen before we can even get to that point. But what you have described is something that in fact exists in some jurisdictions, and it's something that we are seriously contemplating.
So the Prime Minister should come to you and say, Mr. Bailey, we have a national epidemic. I need this out in 2 months, 3 months. It can be done.
Well, in terms of
providing with whatever support you need to make it happen. Really, I'm not trying to be difficult. I just want to identify the doables. The doables in the context of an emergency.
Well, well, for one thing, member, I would think that it's not the entire body of fines and penalties that would be of concern for the purposes of crime and order. But for those that are the relevant ones, that could be done. Okay. But remember, I think I also need to make a point, which is something that I am on record as saying a couple of years ago. The fact of the matter is that without effective enforcement, we can have all the laws we want. They're just words on paper without the mechanisms to enforce them.
Yes. I agree.
But, Mr. Bailey, just back to the point he's making, it's not just having the laws to enforce, but having sufficient teeth to the law. In other words, those penalties. So I think the point, what I'm trying to understand out of the discussion is that from time to time we go through specific acts. I remember we were looking at the Jamaica Tourist Board Act, for example, and we saw where people in breach of something would like $100 a day or $5 a day. Now, obviously, laws that were put in place in 1962 or 65 or 70, there's some correlation that you can make. I think my understanding was that there are two ways in which you're working. One is specific acts. So where we're looking at, cyber crime or something, you're dealing with specific cutting edge, but that there must be something that keeps us up to date and going. But the problem I'm facing in my mind is that if you're going to go through every single law, how long is it going to take you, realistically, to get those laws up to a standard so that okay, right now they're all current, and then put the omnibus in place? If that's the case, we may be speaking about doing it, but may not be something that's going to happen till 2025, but it is very necessary. Do you have an idea of how long your department will take? Because it seems to be your primary, or you have one of the primary responsibilities for it.
In terms of the review, Chair, that will be finished by December.
The review of?
All 600 plus laws of Jamaica that are on the books right now.
All right, so you would have all, by December, you'd be able to table and say what all the penalties should be.
No, tabling now will involve.
No, I understand, but you're saying you would have by December an idea of all what the penalties should be across the board.
Yes.
That's very encouraging. And then from there, there'd have to be a process of really sort of tabling.
There would have to be the legislative process.
The process to do all of these.
Yes.
How many you said there were?
600. I'm not entirely sure the exact number. It's over 600.
All right. And then having standardized that, you then put a mechanism in place to trigger the changes in a timely manner.
We would make the recommendations to the Ministry of Justice, and the legislative process would take its course after that. But there's one refinement I need to make to my statement of yes. It is not simply a mechanical calculation about a fine. Some of the offenses that we're speaking about, depending on the severity of them, depending on the nature of those, consideration have to be given as to whether or not we have a rule of thumb that is used at this point in time, which is $1 million on 1 year imprisonment, and you multiply and divide accordingly, and that's the rule of thumb. However, if there's a particularly heinous offense, the Parliament might want to consider to having something more severe to reflect the disapproval and the heinousness of that particular offense. So, or there may be an offense that, while it is an offense, may not, in the view of the policymakers, require that level of penalty. So that consideration also has to take place. If you simply apply, one of the difficulties is that you simply apply a multiplier to a lot of old offenses. You'll find, for example, that if you multiplied something by even 1,000%, because the fine was so low to begin with, it's still meaningless. On the other hand, there are some other offenses, if you did apply that same multiplier, you would end up with something that would be absurd. So there has to be that consideration that is involved in determination of the fine.
Well, I think we all understand that there will be great complexities in what is being done, and we're pleased. I think from our committee's point of view, what we are most interested in is that the process is ongoing, and that there is a fairly early point at which you expect to be. An early point at which you expect to have at least reached a milestone of a general sense that everything now has been revised to some level, and then the next legislative just from your experience, the process of us, because this would be transformational, I think, in the sense that if we are able to get our the fines across the board somewhat standardized or current, it would help a lot. How long do you think, having made those recommendations, just on experience, I know it's very difficult because it then goes back to the Ministry of Justice, but what sort of time frame do you expect? I mean, what are you working with regards to actually bringing something here to us in Parliament?
I'm afraid that's a bit outside of my remit, Chair.
I can only refer back to Sender after. But no, just to get an idea, because we must have some timetable that we're hoping to achieve with regard to resolving these problems.
The Minister intends to go to Cabinet with the entire study, my words, with its recommendations immediately as the work is concluded. Then I suppose the determination will have to be made. Would the Ministry of Justice carry the whole thing of doing the upgrading, or is it going to be that each ministry will take its portfolio laws and do it? That's a determination that has not yet been made. So I can only tell you we will move to the extent that we are so authorized.
Okay, thank you. Yes, Mr. Member Campbell.
Thank you, Chair. I have a little concern. I notice where you say that the mission of the LRD is to keep under review the law applicable in Jamaica with a view to its systematic reform, to meet the changing needs of the Jamaican society, and to assist in the implementation of law reform proposals in accordance with government policy. And I want to take it down to a very specific area, the issue of land reform in Jamaica. As the last time I checked, there were somewhere in the region of 87 pieces of legislation touching on land registration and the whole land economy in Jamaica. And I think the whole business of registration started back from a piece of legislation which we had since 1889. I don't know of another piece of legislation which has the level of impact on the Jamaican society. And I just want to crave some information from you as to what it is that the law reform unit isn't doing to simplify the process. Because I don't know if I'd be facetious in placing this out there, that those pieces of legislation were never intended to benefit the poor Jamaican. It was intended for the benefit to facilitate the class system, which continues to belittle us, to make us really not develop at the rate at which we should. Because when you go out into the rural townships, I had the unfortunate experience the other day of meeting with some rural residents in an area in Guy's-Hill. And of the 30 people who I met in that classroom, 29 of them were settled on lands which they had inherited in some way, or gotten from purchased, or however they came into possession of those lands. But they had nothing to present to a bank or any lending institution to say, I have this, so I can access equity from those lands. And I'd just like to find out from you what it is that the unit is doing to settle those issues.
Not too sure where to start. But historical and cultural concerns are part of what we do in law reform, in developing legislation. However, the LRD is, we don't make policy, and we are a department of government. So we react to whatever the policy is and assist in sorting out that policy. The example that you gave is one example of why a lot of our laws require some consolidation to make them more effective and efficient in this day and age. More than that, is as much as we can say. We have been involved in land reform issues at the request of various ministries in the past, but nothing has come to us in terms of a comprehensive review. So we have researched land adjudication as a means of addressing some of the issues that you have raised, and have given our assistance and advice in that area. But the work of legal reform, I think the PS mentioned it, that because of both in terms of the level of work and the amount of staffing that we have not been able to be proactive in many areas. And so a lot of our work is actually reactive. That is, we are asked to assist by a ministry. in a particular matter or a particular range of matters, and we lend that assistance. But we haven't had the staffing levels. In fact, as it stands now, for most of the history of the Legal Reform Department, I think the staffing was about an average of 4 persons. We're at our highest right now, in which we have 10 lawyers on staff, of which we actually only have 8. One is a judge, and we have 1 vacancy. So as a result of that, we are, I think, overburdened would be a good word, with the work that we already have to do.
What would you recommend to us in going forward so that we can assist you in getting the department up so that it can achieve your mandate? My friend.
Well, yeah, but you still, as I said, there are 2 spaces still. So I mean, one would, you know.
Bigger budget for more staff?
Well, at this point in time, we are going through a review process in the LRD, and we are going to be, we would be proposing to recruit some more staff. It took some time, but we could do it some more staff, particularly to see, and this is where the difficulty comes in, because what we need would be experienced persons at a higher level. So we are, at this current time, we are reviewing our job descriptions and trying to amalgamate a couple posts to see if we can get some greater efficiency. We've been greatly assisted by the MOJ, and particularly through the JUST program in relation to this. So we have had the benefit of some management reviews, so we can look at some of our systems. We have a new document management system, which, as simple as it sounds, you know, we see some great potential to streamline our work and to make it a lot more effective and more timely. Part of the problem that we have with something like law reform is that it is the kind of work we do is not simply, this is a problem, please give me some legal advice. It very often requires historical research, for example, as to why it is that we are in the position where, why is the law structured like this? What was the rationale for it whenever it was passed, for example? Do those rationales still exist? Have we signed on to international commitments that have an impact on this legislation? What is our social and cultural situation in relation? I'll give an example. The Child Pornography Protection Act, for example, one of the considerations that had to go into it were psychological considerations, issues of child care. So those kinds of considerations bear heavily on the kind of work we do. So a lot of it tends to take a little bit of time, at least, to get done, which is one of the reasons why having a law reform commission or law commission or legal or law institute is something which is still on the books and being a decision that has been taken in relation to it. The PS mentioned that earlier, because that would be an institution that could spend its time looking exclusively on those kinds of matters. In other jurisdictions where you do have law commissions, a project will take 3 to 5 or more years. But at the end of it, they can deliver a fulsome treatise on the law. What are the recommendations, having done the consultations and a draft bill? But those things are heavy-duty matters that need that kind of concerted project kind of focus for some time with people that have the kind of expertise. So we fall somewhere in the middle where that is concerned, where there are lots of pressing needs, so we have to meet those needs because we are being called upon by our client ministries to provide the kind of assistance that they need in terms of the work. But at the same time, we are trying to give work and give the kind of advice that is going to make for effective, meaningful, and hopefully future-proofed sort of laws.
All right. Yes.
There is, as you speak about reform, I I'm troubled sometimes when we are doing these reforms, and what we tend to do is to invite people out of the UK and Australia and New Zealand and wherever they're from. And they tend to, when they come as consultants, and very often we do not see the output taking into consideration our norms, what we have come to accept as our way of doing things. I'll give you one simple example. We had the rules of the Supreme Court. We had some amendments done, and to the extent that we had the size of the paper settled as a particular size, we were told to satisfy somebody, you know, as the gatekeepers of all that is all knowledge and everything, which is that we should change the size of the paper to fit into what the European norms were. I'm not sure. Is there any intention to depart from and to really get down to doing these reforms to reflect what our needs are? Because I'm not convinced that we need, I have this serious difficulty. If I want to lock up a ship, why shouldn't we develop the practice for arresting a ship consistent with what international norms are? And ask the bailiff to go down to the wharf to lock up a ship, and he has to climb a mast and do all the kinds of... Why can't we do it to satisfy what current demands require? I'm not certain. Help me.
Remember, it has been my experience, and certainly in terms of, well, let me start with the work of the department. In terms of our work, and my experience has been with the Ministry of Justice in particular, that considerations about what it is that we need in Jamaica for our own circumstances and to fit our own situation is always a preeminent consideration in what we do. While we can learn from foreign jurisdictions, we can use what they have learned. We don't have to reinvent the wheel, but it has to be tailored to our own circumstances. The particular example that you have given, I am assuming that has something to do with our Admiralty laws as it stands right now, and that it simply speaks to the fact that those are perhaps in need of some serious review.
All right, members are going to move, but just for clarity. Oh, sorry, Member Stewart, go ahead.
Thank you, Chairman, for recognizing me. Through you to Mr. Bailey, how closely do you work with for example, the Bauxite Institute, where we have a lot of our landowners, in particular in South Manchester, and I believe that in Member Phillips's constituency also, where bauxite mining takes place, where a number of our citizens, having had their land titles for a number of years, they have been replaced or displaced but through bauxite mining. And they have been living on properties now and for 10, 15, 20 years and are unable to get their title. Do you work closely with the Bauxite Institute as relates to that aspect there in getting titles for these persons in their new settlements?
I'm afraid that's not part of the work of the Legal Reform Department. Just to reiterate, what we do is to provide legal policy advice in the area of law reform. So to the extent that we are requested by the relevant ministry, for example, to be involved in dealing with those matters, then we would give our assistance as best as we can. But we are not part of any particular project in relation to that.
All right. Just in closing, just some clarification. You had mentioned the Law Commission. Is that the correct term? About that something that would be set up, or you're looking at it? Is what where are we with that? It's in early discussion stage.
Yes, it's still in discussion
All right.
stage.
So no decision has been taken with regard to that yet.
No, because we are also conscious of the cost of setting up another body. We also have proposed that we could have it being partly academic, meaning, you know, somebody from our tertiary level institutions could be, and then we have, so it's still in infancy.
Let me tell you why. I'm trying to clarify, Mr. Bailey. I'm seized by the argument that Mr. Campbell, Member Campbell, made, and I agree with him totally. An area such as land, the legal issues surrounding land, any of us here and the wider country in trying to deal with issues of transferring land or getting a title, especially if you're getting title for a piece of land almost for the first time, issues of multi-generational titles. It is so complex that it's almost impossible to get anything done for 5 years, 10 years, people trying to get a title. Now, and I'm not legally minded, but one of the reasons it seems like is that you have almost two types of system. You have a system like the United States maybe that a man say, well, he have a driver's license, him lose it. He send by mail and tell them they lose him, them send it in the mail and send him back. Now, you say, but how do you do that? Because, you know, it could do a lot of fraud. But the problem is, they will follow up on you. And when they do catch you for fraud, they're going to go to prison. So people really don't do it often. But in our case, we do it the other way. We decide we're going to prevent the fraud. And in doing that, you make so many checks and balances that you can't get to do anything. So the entire population suffers because you're trying to prevent a problem. Now, as I said, just the whole issue of land titling, land reform is complex. Now, in your response, you made the point that you react with regard to your sort of legal reforms. The different ministries and different agencies say this is an issue, and then you look at it, and that's how you're engaged. But in something like land reform that the entire country has issues with, it needs a sort of holistic, it needs a body that sort of drives it. And if I may have misunderstood you, but you then said that that's why a law commission would be good, because something like that would say, well, we will tackle this issue and then push it and pull all the different agencies and bodies together. And it would take a couple of years, but at the end you would come with a result. My problem is, for us in here, in this committee and our parliament, and I join myself with Member Campbell, land reform is probably one of the most important things when we talk about all the number of informal settlers we have, and a lot of it is due to the problems that we have in just getting titles out. And therefore, I think it's important to us to make a specific recommendation. Now, with regard to that, and especially in this area, what I would ask you is this: is it that your suggestion from where you sit is that something like that is better dealt with by having some sort of commission? Or is it that a specific ministry has to take it up and then so advise you? What I don't want is for us to just have had the discussion, it dropped through the crack. Next year we come back and say we're where we are. So I think it's such an important thing that I would like just some advice as to what recommendation we could make to Parliament to really start being specific about how as a government, we all can address this issue that's so important to all Jamaicans?
Well, Chair, my response to that would simply be that we are here to provide the technical assistance to the government to carry out whatever the policy is. So if we are tasked with it, if we are being asked to do that, then that is something that we would carry out with the appropriate warnings about that this will actually take some time to accomplish. There are a lot of disparate pieces of legislation, not to mention there are lots of practices built into that. And as you indicated, it is a complicated area. So it would take a lot of consideration, a lot of research, and quite a bit of time, we would think.
But you're saying that if tasked with doing it, it's something you could do. You don't need the law commission for that. Is that what you're saying? Or better, I'm just trying to get, and not, what we're seeking is advice. It's not really, No,
we could do, Chairman, subject, again,
to a request.
Well, not only that, but subject to expansion of our capacity. Because as it stands now, I have had the experience of having a consultant in my office who inquired about our workflow. And when I told him what we were doing and the volume of work we had and the nature of the work, his comment was that, oh, so you operate a triage system. Triage. The things that are on the things
most
that are
emergency
yes.
first. All right.
And that is a way that we have had to deal with our work. And in fact, since I'm in this forum, I'd really like to commend my staff for the kind of efforts that they are putting.
But members, in moving forward, I think that what we would do, I think in our report, that I know there are a number of issues, Member Campbell, that need reform across the board. And I'm not, but quite frankly, I think for all of us, and certainly for me, I'm in Westmoreland as one of the legacies of sort of sugar plantations and slavery. A lot of persons were just put to live on land and told you can live there but don't build anything but a board house, and you live on the estate, and generations live there, no titles, nothing. And so you end up with a situation, it is a real legacy that we live with, and part of that reform is important to restructure it, to correct these problems. There are programs that have been put in place, but they're small and don't tackle the big picture. And what I would like to say to the committee is that we could recommend that as part of the, going back with the unit, the legal reform department, that one of the specific things we would ask is that the ministry and the parliament and Ministry of Finance find a way that this be put as one of the priority areas to look at, and that it may cost, the staff has to be put in place to look at it, and the cost maybe we need to look at the cost of the additional staff that would be necessary, but it is far more expensive not to address an issue of this magnitude. So as I'm wondering if as one of our recommendations in our report that we address this. All right, with that, yes.
Chairman, I would just say, although it's a small piece of this particular matter, but in 2015, we did do amendments to the Administrator General's Act that dealt with multi-generational estates, but that would fall within their remit. Mm-hmm. So we did do some work, because that was causing clogging in that department where the law did not allow them to deal with with these multi-generational matters.
Yes, but I think that the whole thing has to be looked at. You know, the requirements for subdivision sometimes are so onerous in some areas that you just never get to subdivide. It's just a whole series of things, and we have got to make it more efficient, get things moving quickly, and we're going to, you know, everything is slow in Jamaica. We need to be able to speed it up a bit, and a lot of that is a legal reform. Yeah. I'm convinced.
Yeah. Okay.
All right. So we now move to the AG's department. So, Palmer, if you want to say a few words as you were before, and then we turn over to the Solicitor General.
Thank you, Chairman. The Attorney General's Department, for which the Ministry of Justice provides services subject to constitutional provisions. In recent times, I would say in the last 3 to 4 years, in an attempt to increase efficiency of the department, I was mandated by the Cabinet, along with the Solicitor General, to examine the issue of centralization of legal services. And we managed to get that on our reform agenda, and with a lot of resistance and back and forth, we got approval. We have gotten the positions required approved, and we are now busily seeking to implement the change so that the country may start realizing the efficiencies that are envisaged. I'd like to say that, like all our legal departments, like everything in the justice sector, the Attorney General's Department does a lot of work. Appearing in court to defend the government, or indeed to take action against others on behalf of the government, is one of 5 sets of functions that the department carries out. And so it has been challenged by its staff and complement of attorneys and the whole organization of what is to be done. So we are on the path, sir, of doing that transformation, and that's what I'll say, and I'll hand you over to the SG.
Thank you very much, PS. Good morning, members, staff. As PS indicated, we have 5 divisions, and these divisions include the Constitutional Division, and I would say those are the members of staff with whom parliamentarians would be most familiar as they attend various committee sittings and the Senate and the House of Representatives to assist when legislation is to be passed. The General Legal Advice Division, which actually is the division with the largest number of files, they deal with a variety of matters, including requests for waiver of crown rights, reimbursement of legal fees for police officers who would have been charged for actions taken while they were on duty, other matters, accident matters, and so on. Then we have the International Division, the Commercial Division. So there are 5 divisions, with litigation just being one of them. But litigation is often highlighted by virtue of the strain that the members face due to court-imposed deadlines. So our current establishment is 98, including administrative staff. It was previously 81. And we previously had 41 attorneys, but we now have 50 attorneys. 6 of those positions are specifically to shore up the litigation division. And 3 of those positions relate to the implementation of the centralization of legal services. Those are 3 Deputy Solicitor General positions to assist in oversight of the attorneys that will join the staff of the Attorney General's chambers. These new attorneys will be coming from the legal service units, which now fall under the various ministries. And we expect approximately 45 additional attorneys would come under the oversight of the Attorney General's chambers. So in respect of the new positions, recruitment is underway, as we indicated in our brief. In terms of concerns of our attorneys, two of the main concerns relate to compensation and workload. Now, we have asked for additional staff. The additional legal staff which we have received, we see it as just a preliminary increase. In relation to compensation, of course, that's a more complex issue, which is impacted by the IMF and other issues, but staff remain very concerned. Over the past, since 2012, since the financial years 2012 to 2016, 2017, we have lost 32 attorneys. So that shows the turnover that we face, and some of the persons resign, they go into private practice, they may go into work with international organizations. Some of them also transfer into statutory bodies where the pay is better, and some become resident magistrates. So that's a similar position as that which impacts the Office of the Director of Public Prosecutions. So that would be, so in terms of our reform measures, we are underway. We have a little issue now because we need to get the head of the transition team, and we need the transition team to assist us to implement the centralization of legal services. We are being assisted by the Cabinet Office, and we're very hopeful that this recruitment process will come to a close soon so that we can move forward. Just to say that we have a very high file level. We approximate that we have over 20,100 active files. So that goes to show the nature of the workload that is being faced by our attorneys. We are getting a new file manager system, which we hope will put us in a better position to provide reports and information such as the type that was requested by this committee. In order to provide the information, we actually had to do some physical searches. So I'm very grateful to our registry staff that actually had to go through physical files to provide some of the information that is before you today. But with this new file manager system, which is being overseen by the Ministry of Justice, we do hope that we'll be in a better position to provide information such as that has been requested by this committee and which is often requested by virtue of access to information requests. So I would use that as my opening statement, and of course we are open to questions from the committee.
Kind of a two-prong through Ms. Palmer and to you, Mrs. Foster-Pusey. I have a little interest. I was talking at Mr. Bailey earlier on about getting assistance and what areas of government his unit is responsible for providing services to. And his permanent secretary sought to shield him with the support of the chairman.
It's a hard slap. Can't forget it.
Really, the area that relates to you, Mrs. Pusey, is the constitutional. I know when bills come to your chamber, you review it to ensure it conforms with the constitutional provision. And that would be for all bills, which the government, in this case the parliament, would pass.
That is correct.
And in my other life, you would get drafting instructions from the cabinet and that's where the policy for the bill is set, and it goes through the line and get your input.
Well, the drafting instructions really go to the Office of the Parliamentary Council.
Yes. Before
Yes.
it comes to, yes.
Yes.
But I mentioned that because the policy directions would come there, and then you review whatever bill is drafted by CPC
Yes.
In conformity with the
Yes,
law.
we review the draft cabinet submissions and
Okay.
also comment on them.
Now we have a unique situation, and where a bill does not emanate from cabinet, but from another area of the government, which is the parliament, from members of parliament. How is that treated? Because every bill that comes here and to be passed ought to get the benefit of the technical review to ensure that it conforms to the Constitution, for the simple reason that when it passes into law and becomes an act, it can withstand legal challenge in respect to the Constitution. So any bill requires the input, technical input from your unit. I table a private member's bill which need that support, that review and comment, so that any adjustment should be made to make it legally sound upon being passed. I've never gotten that, as a matter of fact.
Yes.
I am going through the exercise again because I withdrew the bill, which is the Banking Services Amendment Bill, withdrew it to make changes subsequent to stakeholder consultation, needed for it to be redrafted to accommodate those changes, which would normally be by virtue of policy directives to the CPC to draft the bill that you would get, actually get thrown out of the system. Right? CPC does nothing. So it was done by here, which, the truth be told, don't lack the level of drafting competence that reside in CPC. So nothing was done from CPC. Second round again, CPC comes into the picture, and 2 rounds with not getting what the instructions for amendments or changes would be. So I'm now going outside of the system because the system has failed. Or rather, it has failed me, right? Mm-hmm. It has not given back what I sought to get because I'm not a minister. So I don't come from a ministry, so I've been left to swim on my own, though I'm a member of parliament. Not Fitzjackson, private citizen. Member of parliament. The system has failed to support me in my role as MP.
Yes.
Now, I want some clear instruction here, and advice and directive. I am now getting the bill redrafted by a former chief parliamentary counsel because the system failed me. When it comes back, do I send it to your department, Ms. Pusey, to get the review for constitutional conformity, or will I have to just put it before the House again and take the risk that it did not get the benefit of that technical scrutiny?
Right. Well, the situation that you have outlined, I think, is not one that is common. And I think that the Parliament itself would have to look into what are the procedures that would be in place to provide the necessary assistance, since it is anticipated that legislation will be passed. But our work comes to us through the various ministries, departments, and so on. And as far as I'm aware, we are not able to accept work to be done outside of that structure. But of course, I would say that once legislation is to be passed, it would be prudent for it to receive some assistance. So I think that that is an issue which the Parliament itself would have to look at in terms of what is the nature of the framework that would be put in place when private member bills are being pursued. That would be my response. I would not be able to say that work could be sent to us outside of the framework of the ministries, departments, and agencies of the government.
Miss, I'm not a little bit. I'm very combobulated now and discombobulated. The Parliament sent it there.
Sent it to our office?
The Parliament sent it to the AG department for review. The Parliament sent it to the CPC.
So you have been told?
No, I delivered. I delivered it. The Legislative Council prepared it, and I handed it to the Attorney General. I did that personally, so it's not hearsay. I put it in her hand.
Oh, I see.
I also put a copy in the hand with the same bill, making the same request to the Minister of Justice. I put it in his hand myself. So it was delivered.
I see. Well, I think that that is an issue that may be more complex than I can resolve. I would have to await instructions as to how to deal with that.
Member, I think that the point you're making is a very important point, because I think at the end of the day, you are saying clearly that anything that you receive, it is from the ministries, departments, agencies. Understood. But the chief legislative body is the Parliament. And we as parliamentarians, our role is to review all laws that are being proposed and in our thoughts need to be proposed. So what disturbs me a bit about what the member said, I do believe that what the normal procedure should be is that when members officially have a concern, similar to when we hear, if this committee, as we have had in the past, we have questions about the procedures that we're doing, we, through the Parliament, seek advice and you promptly give us your considerations. My understanding is that if in a similar way it is sent from members of the House through the Parliament, that we would get a response from the Solicitor General. Is that not so? Or I'm trying to clarify whether or not in your understanding you did not get something to look at, or is it that having gotten it, you did not feel that it was within your purview to deal with it? Well,
firstly, I must say I'm not personally aware whether it did come. I know the member has indicated that he handed it to the Attorney General, but I must say I'm not personally aware and it was not brought to my attention. But in terms of work that is done on legislation, what I'm saying is that the framework within which we operate now is that we rely on, or we work on the basis of legislation that is being pursued by the various ministries. So it comes under that framework to us. So what I'm saying is that, yes, I would understand that there is a particular need to have some framework in place if it is that legislation is being pursued outside of that framework. But we would have to await being advised as to how to address those issues.
Sure. So, Madam Solicitor General, this bit of legislation that comes outside of the framework, which is in the form of a draft bill, it cannot get the benefit of the input of your department unless a framework is established for it to come to you?
Or unless we're given specific instructions through some ministry, perhaps through the ministry or perhaps through the parliament.
But that's right.
That's my point.
Perhaps through the parliament.
So no, that's
an official request.
No, let me say, it was an official request that came from the parliament via the legislative council. So I just want to be clear. I don't even want to go back. That is only a background. I want to go forward. When the draft bill is done, can the legislative council here, an officer of this parliament, acting through the clerk of the house, as a representative of the clerk, send the draft bill to you, head of the department, to comment on the bill and come back, or I'm going to get lost as I did the last time around? Because the truth be told, the bill came here without the input of your department, because the department failed to respond. I dare to say, I believe, refused to respond.
Well,
because when I would have given a correspondence to the head, the Attorney General, and up to date, I am not aware of any written response to that request made. I can only interpret it as a refusal to act, unless I'm just being taken for granted.
Well, I can't respond to either of those alternatives, but if we are requested to provide advice and it comes through the clerk of the houses, I don't believe that we would be able to refuse, because if it is an official request, we would have to answer and do what is required.
Okay, so just to conclude, when I can say it will come from here to you, and I'm going to put it attention, Solicitor General Nicole Foster Pusey.
I have it written by the clerk, yes.
I would expect that it would go through the clerk.
Yes.
I don't believe that I am open to respond to, requests that just come from MPs.
The clerk.
But if it comes from the clerk of the house, then I would assume that it is work that we would definitely have to undertake.
I am relieved, Solicitor General. At least I have clarity in the path as to get the benefit of the review, the constitutional review of the bill. My only still uneasy one was...
That's where I want to go now. I think that you have cleared one hurdle, but that a race does not make.
Certainly not, Chairman.
And certainly, I don't know whether the permanent sector, but also I would suspect as parliamentarians that if there's a bill that is to be tabled, whether it is a private member's bill or government business, that it should also have the consideration of the Chief Parliamentary Council. We may not be asking them to actually write it, although that in my mind is something down the line should be thought of. But at this point in time, I do not see why we would not have the Chief Parliamentary Council review it before it is tabled in Parliament. It makes no sense to do it after it has been tabled. So the question I would ask is, I don't know the responsibility, the CPC, where they fall in the scheme of things. But again, I think it would be important for us to get an agreement that this would happen in this case, that we could use almost as a.
And before you the answer comes, why I'm raising it here, because more is going to come. And I don't want to go back through this each time around. More is going to come.
Yes.
Thank you, Chairman. I will just concur with the initial statements made by the SG in terms of the fact that it's not normal, right? However, when the minister brought your submission to him, to me, And I did confer with the officer in charge at the time. And I wondered...
The officer of...
of the Parliamentary Council, of the Office of the Parliamentary...
The CPC, Chief Parliamentary Council, or an officer in the department?
The officer who was currently in charge. We do not now have a Chief Parliamentary Council.
Okay.
Today commenced the acting of an individual in that department.
But okay,
yes,
but the Parliament...
Who is Miss Judith Grant.
Miss Judith Grant.
Yeah, she commenced acting today. So I had a conversation because given the unusual nature of how the matter came, and I was assured that it was receiving attention.
Yeah, but go ahead. Finish what you're saying.
So I had left it there, assuming that it would have been dealt with, and it would have
just to say, Ms. Palmer, I think the concern, yes, but I think the concern maybe that the member has is that this is all public business.
I understand.
And this is something which the Parliament has great interest in as a people. And I think the difficulty that I have with what you have said is that here's a member who is piloting something. He has been seeking advice just to make it better, to ensure that the things being requested don't trample on, as you said, treaties and all sorts of other things. It is something that would have benefited from legal reform, from Solicitor General and from CPC. Therefore, if it was brought, what we want to do is institutionalize a system. Yes. Because this is not something that is so frequent that is going to bog down the system. So what I'm saying is that he would benefit, as would all of us, from the advice in the early stages. So
I understand, Chairman, and I am not suggesting that nothing should come from the Parliament. I have no such power, nor would I wish or desire for us to do that, because, you know, persons have thoughts about things that are not going well, as we've been discussing in this meeting, and some things that need to be done. What I'm saying is that although it was unusual, because the only thing I've dealt with before coming from the Parliament,
public business, government bills,
was something on the sex offender registry, which was a private member's motion here, and the report on the motion was sent to me, and Ministry of National Security and the Ministry of Justice, together we dealt with it and created the registry. So that in other words, on the basis of our motion coming from the Parliament. Hence my consultations to see how we would go ahead with the Parliamentary Council dealing with the bill. However, you have not had a response. May I ask if you have sent the revised bill, because I heard that in the news?
No, you know, quite frankly, Chairman and Ms. Palmer, Mrs. Palmer, when I got back the draft, which was to incorporate the changes that the Legislative Council set out, it never reflected it. And we went back to say, look, it is inadequate. It does not do what we seek to do. And I went back again and nothing happened. And I just get sick and tired of it. So, having gotten to that point, I just say, no, let me find somewhere else. And that's why I went to a former Chief Parliamentary Council who was volunteered to do it. Because that's why I said the system failed me. So I have it there now being done. It's not done yet.
Okay.
I have it there being done to be done, right? I have to get a laptop, give the person and prepare them to get it done. That is what the justice system have subjected me to. That I have to go outside of it to get this bill, not for the benefit to me, but for the people of Jamaica. The people I represent, as we all as members of Parliament don't represent our constituencies alone. Once we come here, we represent all of Jamaica. That is what that justice system are subjected to me. And I dare to say, Ms. Palmer, the things that the bill is seeking to correct, it is a failure of the justice system why people are subjected to those unfair treatment by the financial deposit-taking institution. The main impediment right now as we speak is the failure of the justice system to give support, to cause a bill to come to this house and be passed. If that was done, the bill would have been passed already. It has not passed because of the failure of the justice system. But I'm not giving up, and that's why I've gone where I've gone. And I've said to Ms. Pusey, you have given me clear advice to get the benefit of your department's input. I'll take the advice, and I'm going to come back to you when I happen to get it done. I find it unfortunate, quite frankly, and I'm saddened that the justice system of this country don't see any urgency. People are losing thousands and millions of dollars from their accounts monthly, weekly, monthly, and that is not important or urgent.
But if I may, Mr. Fitzjackson, as I indicated, this is not a common occurrence, and as I said, there's no formal framework for it. And so I believe that what would be useful is for there to be the establishment of such a framework, because in the past, what I was advised by my division is that when you have private members' bills, we're not usually involved. So for example, there are pieces of legislation establishing churches, for example, and usually persons would go through a particular MP who would proceed with the legislation, and our office is not usually involved. So that's what I'm saying, the framework. What you would have experienced would have highlighted the fact that there needs to be a framework to indicate how these things are addressed. And so now that it has been highlighted, I believe it would be useful for this committee to assist in pursuing the establishment of such a framework.
Chairman, may I also say that despite the challenges, member, the role of the Office of the Parliamentary Counsel should still be available to you. And just as other ministries hire their own consultant to get their bills drafted, right, so that they can get it on the way, I would suggest that you make me aware when the bill is available.
Absolutely.
And it should be any cost attached to the private consultant to get it done. The department will cover that cost.
The challenge with that, sir, is the bill coming after.
Oh, I can have the invoice provided before. You see, the fact of the matter, I would have to pay it out of my pocket or stand out at the parliament and beg each person passing by to give me a contribution.
Let me have it.
Okay.
Let me have it, and we'll see what we can do.
Okay.
Excellent. You've had a very productive session. Members, I don't want us to leave this. Again, this is an important matter that is a failure of the system. And if we can correct it, it makes it easier and better. So, with regard to the specific case, we're going to suggest Member Jackson, through the clerk of the House, follow the proper procedures, and the permanent secretary, you will submit to both the Solicitor General and Chief Parliamentary Counsel, and let's find a way so that you can get the necessary support to do what we need done here. But secondly, we're going to, as a specific recommendation to the Parliament, indicate that members of Parliament, there must be a formal mechanism in place to support members of Parliament with regard to the advice and how they execute their duties with regard to private members' bill and just getting the knowledge with regards to parliamentary matters, and there must be a process. It can't be sort of ad hoc. It needs to be a specific process that through the clerk to the various areas. And I think that if we can get that and bring that as a specific recommendation, it would be a big step. But in the interim, we can resolve some of this. And I think that the end of the day, what you're seeking is some justice.
I'm pleading for it, Mr. I just fell short of standing.
You should have come with your placard.
I had it made up, Mr.
I want justice.
It made up, but I decided to just plead first, and if I fail, then I would have to revert to that.
But I want to thank I'd like to just thank the Permanent Secretary, others because I think we have made some ground in that regard.
Yeah, Chairman, I just want to say, there are many challenges to the justice system, but we try to do what we can in all the areas that are before us. And as a person schooled in public service, I am very fully seized of the national interest.
All right, Member Campbell, and then I want to move on to...
Well, I don't know exactly whose lap this falls in, but I note that there was a $16 million increase in your rental of property. Over the 16-17 year, you had $57.3 million for rental of property, and this has gone up to $73.6 million in the 17-18 year. Is this increase projected to come into 18-19, where you have an additional percentage increase in the cost of rental?
Yes, it would. In fact, there's a little bit of a debate at the moment. What has happened is that in light of the increase
One second, Ms. Farmer. I think, just break a second. I think they're about to retire. But members, we just want to welcome. We have some students who have come all the way from Howard Cook Primary School to observe the sittings today. And so, on your behalf, I just want to welcome them to Parliament. I don't think they'll be staying for the entire sitting. Sorry about that, Ms. Powell.
Yes. The Legal Reform Department and the Office of the Parliamentary Counsel were relocated to 61 Constant Spring Road with the Ministry of Justice. That space is absorbed by the Attorney General's Department to allow for the expansion of facilities to accommodate the additional staff under the work that and we spoke about earlier. However, there are some challenges. So I think, shall I say, SG, we are perhaps looking for other location.
Indeed, thank you very much, PS. We've been having challenges with what members of staff term foul odors, which come up from time to time at the NCB North Towers. So on a regular basis, we have had to ask staff to go to the outside to await the dissipation of the odors. And that has impacted our decision as to whether we should proceed to retrofit the space, because with the staff suffering all of this inconvenience, we are somewhat at a pause trying to determine whether we should retrofit the additional space or whether we should focus our attention on instead identifying alternative accommodation. So that is a point at which we are, because the ministry has in fact identified a contractor to retrofit the additional space. But I'm still in discussions with our head as to what do we do at this point in light of the fact that the foul odors continue to negatively impact the staff.
Have you had any assistance from NEPA or the other environmental agencies to
Yes,
determine?
indeed. Through the Ministry of Justice, we had tests done to I don't recall, air quality tests done. And at the time that the tests were done, they came back within normal levels. Of course, it was indicated that they were normal at the time that the tests were conducted. So as to suggest that perhaps there could be other times where, were they to come again, it could have been different. But the outcome was that it was normal. And that was the basis on which we said, let us proceed to take the additional space. But having taken the additional space and AIC having gone through different intervention efforts, we are still having the challenge with the foul odors.
So that only affects the new space, or it affects everything?
It affects the entire building, in fact, even other floors occupied by the Ministry of National Security and other entities are impacted.
So this is a new thing, or this?
Well, no, it's not a new issue, but somehow I think it has worsened in the last year or so.
So you're actively considering finding alternative?
Yes, indeed. We have been advised of at least one possible location on Duke Street, which we were told could be ready in say 2 months. So we just have to continue our internal. No, not the Jamintel building, but a building that is under, I think, refurbishment right at this point, and we're told that it could be ready in as soon as 2 months. However, we just need to complete our internal consultations to determine exactly what we will be doing.
In terms of the allocation, for 17-18 you had $73.6 million, and in looking at this new space, what figure are you contemplating that you would have to outlay to acquire those premises?
Well, those premises, the rental would actually be less. However, the issue would be that if it is a standalone building, we would have additional costs that we would have to meet. So, for example, we would have to have our own cleaning. We may have to increase persons who clean. We would perhaps need to get our own security. So although the rental could be less, the overall cost would be more than just the rental.
All right.
May I just one other point, Chairman. In terms of your output in the department, I'm not sure how you go about determining whether or not each member of staff, well, let's narrow it down to the attorneys. How do you determine whether or not each attorney is doing what he or she is obliged to? Because I know you mentioned something like 20,000, is that the
over
number?
20,100 active files.
And and you have what number of staff dealing with those matters?
Well, we now have 50 attorneys on the establishment, but 9 of those positions are new and are just being filled, and 36 attorneys or 37 attorneys on the ground at the moment.
Right, so you're looking at an assignment to each attorney of how many cases?
Well, it depends on the division. For example, in the litigation division, we estimate that persons may have over 200 files that they are handling, but persons get work according to the divisions in which they are, and the work differs, the nature of the work differs. Right. So we wouldn't be able to say 200 across the board, because the file load in each division differs.
But in terms of the international best practices, what would you say is the number of files? Given the nature of the complexity involved, what would you say that the assignment level ought to be?
Well, that is it. Although we have done a sort of an unforensic estimate as to how much additional staff we would want. We do not really at this point know what would be an international best practice, and we would hope that when the transition team is in place, that is a part of the work that the transition team is to assist us with, to make a recommendation as to what would be the best staff complement to carry out the work that we have. And we would expect that they would be looking at such matters as international best practice, but we do not know at this point.
SG, there was a, well, not so recent judgment which seemed to put your department in a not so good light in terms of the delay which takes place in that. Have you been able to resolve the issues which led to that particular adverse judgment?
Well, actually, on the heels of that judgment, we ensured that in making our request for the adequate staff to implement centralization of legal services, that we added to it this judgment. We referred to the judgment, we referred to the strain that is being felt by our litigation attorneys, and we made a special request for a shoring up, so to speak, of our litigation division. And we are very pleased that by virtue of the Cabinet decision earlier this year, that Cabinet responded to our request, and we were provided with 6 additional positions for the litigation division, in addition to a Deputy Solicitor General position, which comes with centralization of legal services. So although it was indeed quite a painful outcome, we, you know, as it is said, in every crisis, there's an opportunity. So we used the judgment to support our request for additional staff for the litigation division. And we're very pleased that our cry was heard. Of course, we believe that this may be just a preliminary step to assisting us, but we're still very grateful that there was a response. We referred to the judgment, there was a response, and we're filling those positions right now.
That 6th position was part of the 17?
It is a part of the 17. So there were 9 attorney positions in all, 3 of them related to the centralization organizational structure, and 6 were specifically to shore up the litigation division.
All right. Just in closing, I want to just clarify something. The centralized services, the agreement was made about 2 years ago?
Well, in 2016, Cabinet agreed in principle to centralization of legal services, but indicated that a detailed framework would need to come back to Cabinet as to how it could be implemented. So that was in 2016, and then earlier this year, an implementation plan was actually presented to Cabinet and was approved.
Okay, the question I would ask, just for clarity, what has happened over the years is many department agencies and even some ministries now have their own legal officers. It is felt that by centralizing, you put the legal services and let everybody use that. You're still complaining yourself, the DPP and others, that whether judges, other areas, people are leaving. And one of the areas you say they're leaving for still is the agencies and departments. The 2 points I would ask, number one, the fight back that you got was largely that there are some areas that may need very special technical knowledge, and that, say for example, the Civil Aviation Authority would want to have a lawyer who is specific to civil aviation law. And so they were holding out. And I'm not saying they were, I'm just saying that specific people were saying that they needed, number one. And number two, in big transactions where we were going up maybe multinationals having a negotiation, say like the Port Authority for Port, that with the high-powered lawyers, they felt the need to use a high-powered legal team from maybe a big organization. The question is, in going centralized, has that A, been resolved sufficiently in your mind? And two, has, by virtue of putting this in place, you're getting additional legal staff? Is it that the departments and agencies are now stopping the hiring, or not just stopping the hiring, but actually relieving the legal staff that they have? In other words, this whole process was to create greater efficiencies. I suggest as a committee, we would ask the Cabinet Secretary to advise us as to what has happened in terms of the lawyers that are hired amongst the departments, agencies, etc. What is the status with that now that you are assuming the centralized role? Because what would be unfortunate, I think, and what could very well happen, is that you do the centralized service, hire the new lawyers, but you still have all the other lawyers in the departments and agencies. We'd really like to know if that is actually taking place. So my two questions would be that, and two, how do you respond to that sort of specialized discussion?
Okay, well, firstly, I think that it needs to be clarified who would be included in the centralization of legal services. And the departments that would be involved, it's really the ministry legal service units, in addition to the Office of the Services Commission. So the various ministries, whether justice, culture, education, etc., their attorneys on the establishment are the ones who would now fall under the heading of the Attorney General's chambers. So it would not include statutory bodies such as the Civil Aviation Authority. They are, in fact, different entities. They are bodies corporate who would still have their own arrangement for their legal officers. In terms
isn't that weren't the statutory bodies the ones that had the majority of the legal services? I was under the impression that most of the ministries used your services.
Not to my...
That it was really the majority of it were the statutory bodies,
yes, well,
which could fund it.
Yes, well, no, my understanding is that it was always related to government attorneys. The statutory bodies have their own individual arrangements.
Tell me if my understanding is right, Solicitor General, is that the norm is that the ministries make the submission to the Attorney General chambers for advice, and that advice is what completes the process of legal advice. What the centralization exercise is seeking to accomplish is to pull those legal officers from being a separate legal officer to the ministry to being part of the AG's chamber. So when that person give advice, it would not be the ministry advising itself, but it would be the Attorney General's chamber that is providing advice. So you short circuit the process from ministry to AG back to ministry to right there in the ministry, you get the AG's advice. So that legal officer there automatically becomes an attorney of her chamber. And therefore any directives or legal supervisory directives would come directly from you or any senior officer there.
Yes, that is correct, Member Jackson. So that the arrangement would be that the ministries would still have legal officers located within the ministry, but those legal officers are seen as members of the Attorney General's chambers. So there may still be some matters that they would still have to refer to where we would call headquarters, but there would also be matters that those attorneys would handle at the local level, and when they give their advice, it would be seen as advice from the Attorney General's chambers.
Solicitor General, why I'm grappling with this, there's a public sector transformation that's supposed to be taking place to make things more efficient. What I hear from you indicated that you were getting 17 new members of staff, or there was some number you
17 for the head office, so to speak.
Exactly. Now, if you're saying you're getting 17 for the head office, but that those in the ministry now would also be considered, what we're looking
45.
at is not an efficiency exercise, but an expansion. So that's the point I was making. To me, it doesn't seem that the centralization is to make it more efficient, but that we are actually taking on more people. We will end up with more lawyers at the end. So it's just for us to understand and to get the rationale so
right.
that the committee can determine. So, but I don't see, in other words, when you were talking, I got the impression that you would be taking over some of the services of the different ministries and agencies. So you have said now that the statutory bodies will be keeping their legal officers. It seems as well that the ministries will keep their legal officers, but they, while stationed there, will become part of your staff.
That is
but
correct.
You're also taking on additional staff.
Right, but the additional staff, some of the additional staff we received is to enable us to have the proper supervisory structure for the additional attorneys who will fall within our jurisdiction. So, for example, the 3 deputies Solicitor General are to ensure that they can assist in supervising the new attorneys who will fall under our jurisdiction. And then the 6 were for the litigation division.
Well, no, I'm not at all saying that that's not a good or bad thing to do.
Yes.
All
yes.
I'm saying is it is not members what my understanding was going into the exercise. So it would be important, I think, as a committee for us to at least get an idea of what this centralization permanent secretary entails, means. If at the end of the day you expect you're really expanding legal services across the board for the government, whether there's a downsizing. In other words, how this efficiency exercise, what it is going to entail, because it does, I mean, on the face of it, it seems to me at this point that it's an expansion of the services.
No, Chairman. 2 things. Currently, the ministries, their departments get advice from the legal officers there in-house. But then you send it on to the Attorney General's department to get the official advice of the Attorney General's department. What is now being implemented as approved is that those attorneys will be trained and there will be appropriate protocols organized, so you will get one advice, right? So not your ministry staff advice and then the chamber's advice. And so we cut out one piece of the process. The other thing we must remember is that the Attorney General's chambers has been overburdened. And so just to shift to increase the efficiency at the ministry level will not address the issues that go to the chambers, right? When you have all of the litigation matters, when you have, in other words, the ministry's team only really goes to the general legal advice section and the constitutional section. But the other aspects of the work of the chambers, it remains, right? So what we're doing is a central department efficiency, so you get a greater responsiveness of that department and the shortening of the process for ministries where you get one advice and not 2. The other thing in respect to the rationalization process, we are doing rationalization, and that is going to bring a lot of entities within ministries, and therefore there will not be those, and then perhaps some of these statutory bodies will be part of that process. And so there's the issue of how you deal with their staffing, which I don't have details about. So it's not an expansion, really, if you look at the fact that the department should not have been carrying the load that it is carrying with the demand for staff.
And if I could supplement, PS, just by way of example of the efficiencies that we would expect, there are certain matters that we deal with at headquarters, so to speak, accident matters, refund of legal expenses, waiver of crown rights, where what we anticipate is once we settle on the particular principles that should be borne in mind in providing a determination that some of those matters would be determined at the ministry level, at the ministry legal service unit level. Once we agree on all the principles that must be taken into account, they could be determined at the ministry legal service unit level and not necessarily have to be sent up to headquarters, so to speak. And we have already thought that matters such as accidents could instead be dealt with at the legal service unit level, and all of those officers would now also be in a position to recommend settlements and so on, and it not have to await determination at our level. So that is a part of the efficiency that we would anticipate. Some matters that we now deal with at headquarters could in fact be dealt with at the local LSU level.
Okay, no, look, I do understand that, as you said, there's always need for more personnel in the unit, and that by almost having outstations, it becomes more efficient because the officers that are there. I'm just saying that at this point in time, the legal officers in the ministry will remain in place, although the reporting is different. But there's additional staffing at the center to make this happen, so that at this point in time, the centralized services is not to create less members of staff in the initial round, but as a matter of fact, there will be an expansion, but you can't say what will happen with the next phase of rationalization.
Precisely, Chairman. And, you know, a desk audit was done in 2013-14 of the department, and I mean the numbers of files per person was mind-boggling. You know, you have one officer dealing with thousands of files. It just doesn't happen. It doesn't work. So perhaps down the road with the file manager, with all the things that we're doing, right, things will become less onerous, but all of those files that are in the chambers now need to be dealt with and the matters concluded.
All right, members, we now move on to the Administrator General's Department.
Thank you, Chairman. The Administrator General's Department is one of the flagship entities of the Ministry of Justice. They have managed, I remember years gone by when they were in the news with the call-in shows all the time. That is no longer the case. Several amendments that we did, in fact, some new legislation has created some real efficiencies for them and have allowed them to settle estates of many clients, and Mrs. Brown will tell you more about that. Fundamentally, though, we are putting in a trust management system which is to be completed tomorrow. Yes. Tomorrow, the establishment of the system. And that will in no small way, again, address the efficiency of the office. And persons will be able to get their matters dealt with. The ability of the department now to deal with probate, yes, of their estates. Remember, they only deal with estates where minors are left and there's no will. Am I right? Yes. So that's some of the work. From time to time, the department brings forward their own need for legislative amendments to create the enabling for them to be more efficient. There's a lot of attention in the Administrator General's Department on efficiency of their operations and improve client service, and they are one of the major best.
Corrupt.
There are islands and whole civilizations unchanged by science, economics, or religion.
A nighttime pilgrimage through the village.
Life has been the same in these places for centuries.
The children worship the catch.
Unusual Cultures is a fascinating look at people and their practices and the significance they play in day-to-day life. Unusual Cultures, Sundays at 12 noon. Catch it again Tuesdays at 11 a.m. and Thursdays at 8 a.m. on PBCJ, the People's Station.
Start your day with some encouragement from New York Times best-selling author and practical Bible teacher Joyce Meyer.
God is not mad if we've not arrived. He's just happy that you're here today wanting to learn more.
You'll be refreshed and strengthened as you hear powerful messages of hope and transformation.
God, I want you to lead me and guide me, and I'm going to do what you want me to do. I don't care what it costs.
Watch Something More on PBCJ TV every Sunday at 9:30 a.m. and a repeat on Sundays at 9 p.m. See Dynamic Ministries, experience worship beyond the veil, the uncompromised Word of God from Bishop Dr. Harold V.
In the name of Jesus, every chain shall be broken, every chain shall be taken.
That's Something More, Sundays at 9:30 a.m. on PBCJ TV. Don't miss this opportunity to be blessed.
My mother tells me that when I was a teenager, she noticed a dip in my mood every year around the time of exams in school. In my second year of university, I experienced a number of challenging events that led to my very first panic attack. And in my fourth year, I went through the darkest period of my life where I isolated myself from my family and my friends, and I struggled to complete my degree. And I was diagnosed as clinically depressed with anxiety and given prescription medication.
While you need a doctor or a psychiatrist to diagnose a mental disorder, there are signs and symptoms that as individuals you can look for. You can refer them to the community mental health team for assistance.
If you or someone you love is suffering from a mental illness, it's okay to ask for help. And always remember, mental health matters.
No, son. A verb is an action word.
Parents need to become more involved in their children's education.
Parents are the first and in many cases the most important teachers.
Read with your children. Review their schoolwork. Visit their school.
Tapping and rapping and slapping, I said.
Nice! High five! Woo!
A good education will never decay.
Yeah, sometimes in the house, you feel traumatized because shut up and you know where to turn. The baby them start ball, it just feel, you don't know what, you don't know which end, while I'm outside. And we can build a better Jamaica, by love. But some of we just have a, naughty heart against people. But we can help each other, we can build each other, we can make a foundation here for better. Let's create a safer Jamaica. We can do it and we can build it.
A message from the Ministry of National Security.
There's a long-distance relay that's still on. Many have taken it this far, each leg as important as the next, each challenge faced with determination. Now it's your turn to take the baton. People living with HIV and AIDS and those who are vulnerable need your commitment. It stands in the way of a better quality of life for all of us and our self-respect as a region. It stands in the way of victory in the fight to stop the spread of HIV. Reject stigma and discrimination. Get us to zero.
Jamaica, lush, beautiful tropical island.
Warm, loving, hard-working people.
Renowned international achievements.
Yet daunted by corruption, poverty, crime, and violence.
Realizing the need for better governance, transparency, and accountability in our affairs, National Integrity Action (NIA) was launched to combat corruption and build integrity in Jamaica.
Non-partisan, balanced, and fair, NIA has embarked on a broad program to help build a movement for integrity.
Persistently pushing Parliament to pass crucial anti-corruption laws.
Training public officials, working in communities among students and the youth. The Governor General's I Believe program.
NIA is expanding, now a membership organization.
Jamaica can curb corruption, but more hands are needed. Join NIA today. Let us together make Jamaica the place of choice to live, to work, to raise families, and to do business.
And the multi-generational estates. We are now able to issue or own what would be called a grant from the court, but ours is called an instrument of administration. And we are issuing these at less than 3 months, in less than 3 months. So it's also good for the courts because they won't have, if we are filing 250 per year, they don't have that number to deal with, and it will free up the court to handle other probate and administration matters. The instrument of distribution is one that we give in multi-generational estates. So there will be no need for beneficiaries who have died during the administration of these estates. There's no need to apply for a grant in those estates. So we just issue that instrument and we would name the estates that would fall under it because several persons would have passed since that matter came into the department. And those are the matters that we have segregated, and it is under one, what we call branch or unit. And we have started the process of issuing and passing on properties. And as you can well imagine, most of the properties would be, or most of those estates would have properties as well. Those are some of the highlights. Mrs. Palmer did say that we are still the running best customer service agency. Single location. We also have an office in Montego Bay, small office of 3, a case officer, and 2 property officers. So they handle the 2 property officers would manage the properties in the Cornwall region. So those are my comments, and I will await, if any questions that you may have.
Thank you, Chairman. I note in your business plan for the period 17 through 20 that you have 107 posts within the AGD. But on the other data which is available on your website indicates that you only have 83 positions filled. And the government of Jamaica makes an allocation to you to cover salaries and expenses amounting to some $382 million.
We do have, you're finished? Sorry.
Let me just, that is the information. Against that background, because somehow I got the impression, and perhaps mistakenly so, that you are an independent unit and you are to reach the point where you become self-financing. When do you anticipate that you will reach that point?
Remember, we do have 107 posts, and we are currently revamping the website, so we will ensure that the correct information is on. The Ministry of Finance had approved 24 new posts in 2015, and we have been filling those posts over the years. At the moment, for this year, our salaries budget is 40% of the entire budget, but it is normally 80%. The reason is that there are the capital projects going on now, the Thames and so on, so that increases your overall expenditure budget. We are working towards becoming self-sufficient, as it were. It is very difficult now because of the backlog. The backlog estates have no money. You might find about 10% of them with funds or so. If we can do that in 5 years, I would be very happy. But we will work towards that with Thames implementation, and we intend to, whilst we can't increase the number of staff in the backlog section, we will have projects. There are many attorneys who have just graduated from law school, and the plan is to employ at least 4 this year for the rest of the year to assist with the multi-generational estates and some bona vacantia that we have that we will liaise with the SG at some point in time. We have about 500 or so of them. We have some in backlog, and some are current. You'd never believe that there would be current matters where there is no beneficiary to claim or who would inherit.
Pop out at me. You receive about 350 new estates each year?
On an average.
Yes. But your business plan suggests that you're generally only able to deal with about 20% of those estates.
20% of, I am not so sure what, because we manage all the estates. The investigation aspect of the 350 of those that come in each year, unless we get the information, we can't go forward. We now have a very robust public relations program going on. We have employed a public education manager who does the public relations. We go out to both to public and private sector entities. We have road shows. We are about to have one in Montego Bay, not a road show in the city center, but one at the location where we are situated. So we do handle, it's very difficult to cover all the cases. The SG mentioned the number of cases assigned to one attorney. We have 200 cases in the general section, at least 200 assigned to a case officer. And what we're actually doing is we're handling families. We're dealing with families. And one estate could have more than one family because the deceased, who is a man, of course, could have a family in Montego Bay, in Westmoreland, Portland. So we have to make sure that we administer properly and that each child, whether belonging to Mary or Jane, it gets the same attention and is entitled to the same entitlement that comes from their father's estate. So it really is not, and you have, every day running of persons calling you, of beneficiaries getting sick, of not enough money in an estate to assist these beneficiaries on a daily basis, or to assist with insuring the house, preparing the house. So it is a difficult job. Don't know if I've answered your question, Mr. Campbell.
The 20% is really what concerns me, and you know, what specific steps are you taking to take that percentage? Because it seems it's rather low.
Well, I would really like to see where that 20% comes from, because I'm not understanding exactly. Because I don't know if it's closure, if
yes, you're only able to take about 20% of your estates received annually to completion.
But we can't, okay. Estates can be closed. Things that we take in, estates can be closed in a day or two. If there's a minor, and I'm trying to answer that particular question by giving all the different scenarios. If there's a minor, for instance, and I have an instrument issued in that estate, that minor might be 3 months. So we won't be able to close that estate until that minor attains majority. So we'll have an estate for 18 years.
Well, so when these figures are published then, and you say you're only able to take it to completion, you're speaking specifically to those that you wind up.
Yes, to those that we complete, right, those that we complete. So there are many estates there. We can have an estate where the child is en vente sommaire and is not yet born. So, you know, if it is a child of a marriage, it is a child of the deceased.
Very well.
Only ones in marriage?
Sorry?
Only unborn in marriage?
They can prove paternity. The child who is born outside of marriage, they will have to prove paternity.
No, I thought you mentioned that in the case of a pregnancy, the death occurs
before the child is born. Yes.
Well, you mentioned in marriage.
In a marriage, the child will be deemed a child of that marriage.
Suppose the pregnancy is
outside, then they have to prove paternity after that, to say that the deceased father is indeed a father under the Status of Children Act.
Okay. You have many of those cases?
We have a few. We have a few.
Okay. Okay. In closing, Mrs. Brown, I understand that, as your permanent secretary said, the department is very efficient, and I'm pulling everything together. But however, there's still a large backlog. I would suggest, just from some personal experiences, that some of it is also created again by some of the onerous or maybe onerous requirements that have been put in place to prevent corruption, prevent problems, which really slow down the system, rather than treating it on the back end. And again, I suggest that I remember a case that I discussed with for example, affidavit that had been signed by a notary public who was on the record as a notary public in New York, but the requirement is it has to be in person or confirmed by the consul general or the ambassador, rather, whereas these things are online, which, you know, today, if you have a notary public that is registered, you know, it would figure that that is what they are. But we have some specific things that create problems, and I'm just wondering if you have made any suggestions, and again, here the legal reform unit, all these things. Do we actually move to take out some of the impediments? Because it can't be that the only thing we want to do is to give more staff to work more. But the efficiencies, are we not looking at some of the issues and cutting out those things to really speed up the system and take out the bottlenecks? Because, as I said, there are some of the requirements that I believe we could revisit.
Chairman, the amendments that we made 2015, that has allowed for increased efficiency of the office, of the department. were recommendations from that department. So if I speak for them, I would say they are constantly looking at what else we can do to modernize the service. And perhaps, Mrs. Brown, your team will look at this particular matter, amongst others, as we continue to always keep it under review to make sure that we are serving the citizens.
I don't say no, but again, just as I sit here, I remember a case where someone was married. The son was making an application, and his parents were married for 70 years or 60 years. I mean, the mother was now over 90. And they had all sorts of information, you know, because they'd been married and lived together all their life. But in settling, the mother was alive and now making the application. The father, of course, had passed away. Mm-hmm. And the AG's department required the marriage certificate, and they'd been married in like 1928 or 38 in Louisiana or something, but it was a requirement, and almost like the son had to go all the way down there to dig into some department thing. And I'm just saying, there was so much other information that was valid. They were married together for how many years, lived together, house together, everything. But it is some of these specific things that create an impediment that eventually frustrates the system. Now, I'm just saying, are these were, when that was being done, the then Minister of Justice, I spoke to him, that's why I remember them clearly. And I'm just saying they must be in all our agencies that impact our people while maintaining probity and ensuring the system has its safeguards. We have to start ensuring that the efficiencies are in place to allow the system to operate, or we will constantly have a situation where you are 2, 3, how many cases are we in backlog? Or how many do we, sorry, not backlog.
2,000, a little in excess of 2,000.
And therein lies, if we are really going to resolve these issues, where it cannot be just, I suspect that having made those changes that were made 2 years ago, or whenever it was, that you're being able to work more quickly. So you may have had a bigger backlog before, but we need to, it needs to be a process of ongoing reform, or we will always have these backlogs and the system will be slow.
Mr. Chairman, there were other amendments made at the same time that ours was made. I recall that with a will, where if the witness is a beneficiary and signs that they can, once they can prove that there was no undue influence or so on. So there were several other amendments made. With respect to the marriage certificate, it protects the estate, because anybody could say, I am a wife. I understand the older matters, but that is why it is so important to have the estates dealt with as soon as the person passes, because when it becomes so complicated.
No, you're getting me wrong. I'm not saying a marriage certificate is obviously the ideal. I'm saying there's so many other official documents that can be used today and produced, but our law tends to be very specific, and then you're guided specifically by the law. So it's not 1 and 2 cases. I suspect you have hundreds where this is a problem. And I'm saying unless we move to deal with some of these cases and change the legislation, I'm just saying the other side of the coin is where you do catch people that commit fraud. Lock them up. But you can't bog down the entire system and make people wait years because you want to prevent it. There's another way of dealing with it, and I'm just saying, and quite frankly, even though we put all these safeguards in the place, I dare say people still slip through. So I'm just saying that can't be the end all and be all, and therein lies the recommendation, so that in terms of efficiency, we need to get to the point where these things are quick and seamless and not quite as difficult as it is at present.
We will speak with the permanent secretary on that, sir. We will definitely make further suggestions, because these are far-reaching amendments, and we want...
Already, yes.
Already. So we will continue, as the PS just said, we will continue to make suggestions.
Let's mention, we have changes where electronic, evidences are accepted, where we used to have hard, they have changes to facilitate. That's why I just thought about that as you mentioned it, Chair. And as you said, things are on the website. If you can electronically pull them down, just a thought.
All right, members. I think we've had a very informative discussion today. I'd like to thank the representatives from the Ministry of Justice, led by the Permanent Secretary, and from the Legal Reform Department, the Attorney General's Department, and the Administrator General's Department. Thank you all for coming. I think it has definitely been a very interesting and informative day for us. I want to... Yes.
Very informative.
And productive for you.
Yes, sir.
Absolutely.
Yes, sir. One of my better meetings.
I want to thank all the students from the Howard Cook Primary School who have come today to the sitting. The trusted representative from the Ministry of Finance, Mrs. Morrison, thank you again. Always here, on time, thank you. And you members, thank you. So it is not intended, I think we have exhausted our deliberations with the Ministry of Justice. So I'd like to thank you. And it is our intention next week we will be taking the Ministry of Industry, Commerce, Agriculture and Fisheries, including next week we'll have, are we taking all of this? Well, members, we have JAMPRO, the anti-dumping, the Cannabis Licensing Authority had indicated we had really wanted them specifically, and I think it would be important to have them come before us. So we want a fulsome update on that. There's been a lot of discussion, and we could probably lead off there. We have the Consumer Affairs Commission, JAS, and RADA, the Sugar Company of Jamaica Holdings Limited. I'm not certain where exactly the Sugar Transformation Unit sits within that, but there's a unit that deals with the... Yeah, so we would want some specific... what is this? That's after. Huh? Yes, they fall, it says here, JAS under the ministry. Agricultural Society. I'm not... I thought it was... Well, I'm not certain. We will check, because I didn't know that as a government. I think that's a mistake. All right, but certainly next week we would take the cannabis, and we'll work out an agenda, and we would take rather the week, either that week or the week after. Members, again, I just say to you, if there are any specific questions on this that you would ask, please relate it to Ms. Bailey, and the questions can be forwarded to the ministry. With that, members, thank you for your attention, and with that, this meeting is now adjourned.
Thank you, Chairman.